Thank you all for joining us. So good evening, everyone. This presentation is on our Subtitle 25 update regarding trees and vegetation in Prince George's County. Specifically, we will be discussing proposed changes to our Woodland and Wildlife Habitat Conservation Ordinance and our Tree Canopy Cover Ordinance. My name is Megan Reiser, and I'm a planner in the Environmental Planning section of our county's Planning Department. Here with us this evening are other members of the Planning Department, including other staff from the Environmental Planning section who have been working on this update. Our team includes our supervisor, Tom Burke, and other core staff include Kim Finch, Marion Honnessy, and Mark Juba, all here with us this evening. I would also like to thank all of the staff who helped bring this meeting together, including our publications and public relations staff, as well as our support staff, Maureen Farrington, for their tremendous efforts in getting the word out about this meeting. Maureen is also here with us this evening. Also with us this evening is our Countywide Planning Division Chief, Katina Scholars. I would like to turn it over to her now for introductions of all government officials that we may have here with us tonight. So we ask that if you are an elected or appointed government official, federal, state, county, municipal, who would like to be recognized, if you could please virtually raise your hand at this time. We will enable your cameras and microphones should you choose to say a few words, and we'll call on you just kind of in the order that you appear in our list of attendees. So Katina?
Yes, good evening, everyone. Thank you for joining us. My name is Katina Scholars, Division Chief of Countywide Planning Division in the Prince George's County Planning Department, where we focus on infrastructure elements of development as we do planning. That includes transportation, environmental, and historic preservation planning. I'd like to start out by I'm very excited to introduce to you our new planning director who is here with us this evening, Ms. Lakeisha Hall. And I'd like to turn it over to her and first say thank you for joining us. And if you like to, please, if you'd like to share any remarks, please do so.
Thank you very much. I hope everyone can hear me okay. I had to step out of another meeting, but this is a very important meeting that the team has put together. So I wanted to thank everyone for making time this evening to engage, to learn more about the state requirements, to learn more about the integration to Plan 2035. I've been here going on almost 2 months. Been really excited about the work that is on the books right now for the team. Looking forward to more collaboration in the community. And I'm grateful for Katina and her team for pushing this effort forward. It's a very, very Herculean effort, and they've done a phenomenal job. So thank you, Katina, for the time.
Thank you, Director Hall, for those remarks, and thank you for taking the time to join us out of your meeting. So I will go ahead and continue. And if are any elected or appointed officials here that would like to be recognized, please raise your hand. I don't see any. I'm going to turn to our admin, Ms. Maureen. Do you see anyone raise their hand that I didn't see?
I'm not seeing any hands raised right now.
Well, okay. Well, then, Megan, I will turn it back over to you.
Maybe they choose to be anonymous.
Oh, there's one. Wait, we got one. Yay. Okay, so I see hand raised for Susan Whitney. If you would like, you're welcome to introduce yourself and share any remarks or that you would like to with us in the group.
Hi, how are you? Thank you for inviting me to speak in my very dark room. Yeah, I'm just excited to hear what you have to say. I think it's really important. I am one of the 2 District 2 representatives from the City of College Park City Council, and the City of College Park has been doing a lot of work trying to preserve our own tree canopy, and I'm very interested to hear what you have to say today. Thank you.
Thank you, Councilmember Whitney. It's an honor to have you here. We have another one who has raised their hand and named Lauren. If you are welcome to go ahead and speak, if you'd like. Lauren, you're muted, but you're welcome to introduce yourself.
Yeah, you should be able to unmute yourself, Lauren.
Let me see. Let me help you. Maureen, can you do it and see maybe they're not being able to find it?
Oh, I think it's on their end. They, yeah, like their mic and camera are enabled. Oh,
Okay. I don't see them on the list anymore, so I think it looks like everyone's unmuted now. Oh, okay. Okay, so it looks like that didn't go forward. So, Lauren, if you do want to say something at the end, you're more than welcome. We're going to keep going. So, and now I'll turn it back over to you, Megan.
All right. Thank you so much. So I'm sure everyone saw when you joined the meeting that this is being recorded. So we will post the recording on our website when we're able to process it the next day or so, just to have it up there for reference purposes. So I did just want to cover a few housekeeping items. There were over 200 people registered for the event. So we're really excited to have so much interest in this topic. We would like to take the opportunity at the beginning of the meeting to outline the meeting format so that everyone knows what to expect for the evening. We will be treating this sort of like an informational webinar style presentation because our goal is to get the material out and reach as many people as possible. Our topic tonight covers the Maine Forest Conservation Program changes coming to us from the state and how we are proposing to implement them. Please keep in mind that this is a legislative change, again, coming to us from the state. And as a legislative update mandated by the state, there are minimum program requirements that need to be updated and associated deadlines we are trying to meet to ensure that our local program remains compliant. We also want to distinguish this effort from other processes that you may be familiar with from the planning department. That is, this is not a hearing where folks may be accustomed to being allotted a set amount of time to speak. This is also not a community planning meeting for sector or master plan update where we typically solicit feedback to be incorporated into those neighborhood plans. The purpose of this event is to disseminate the information about the proposed legislative changes required by the state. With so many in attendance tonight, we will not be able to accommodate verbal comments, but for this meeting, we are asking that folks type any questions into the Q&A, which is similar to the chat feature. We will have staff moderating the Q&A behind the scenes during the presentation. The Q&A differs from a chat feature in that our moderator will need to read the questions and comments that are provided before releasing them to be posted for everyone to see. So if you don't see your question posted, rest assured that we have received it and are processing it. Our goal is that we may be able to group like questions and concerns together and provide feedback either in the Q&A as a response or as a topic for discussion after the presentation, or possibly both. So we do plan to have a panel-like discussion after the presentation to address some of the most frequently asked questions. We will try our best to address all of the concerns, but we may be limited in our ability to address each and every concern during the meeting. If you feel that your question hasn't been answered by the end of the meeting, please let us know. We ask that you keep your comments to the topic at hand. If there are site-specific concerns regarding ongoing environmental issues in the community, we would encourage you to visit our website and reach out to our environmental planner of the day, who should be able to assist you. Our contact information is up on the screen now. Unfortunately, given our time constraints to meet the deadline set by the state, we will not be able to consider any questions this evening that are not directly related to the legislative effort. And again, we are here this evening to discuss proposed legislative changes to the Woodland and Wildlife Habitat Conservation Ordinance and the Tree Canopy Cover Ordinance as mandated by the state. Before we move on to the presentation itself, I just wanted to let you know that the slides will take about 30 minutes to go over. So without further ado, I will now move over to the presentation itself. Maybe. There it goes. So why are we doing this? The last legislative session, the state passed bills requiring changes to the Forest Conservation Act, which each jurisdiction implements locally. There were many changes in the bills to be incorporated into our local program with a very short turnaround time because the effective date set by the bills is July 1st, 2024. This gave us, as the staff for Prince George's County tasked with implementing this program, about a year to complete a very significant update. While this may sound like a long time, there are many steps along the way that we needed to complete. As with any legal changes, we had to start with interpreting exactly what the state bills were requiring. Next, we looked at how those changes would fit into our local processes and procedures, and where those changes would best be reflected in our local code. We spent several weeks on each of the main topics, comparing the state language to that in our local ordinances, pulling data and analyzing different scenarios to ensure our final proposal not only meets the state requirements, but also makes sense for the county. To quickly familiarize you with Subtitle 25, there are 3 divisions. Division 1 contains general regulations regarding trees and rights-of-way and is mainly implemented by the Department of Public Works and Transportation. We are not proposing to make revisions to Division 1 at this time. Division 2 is the Woodland and Wildlife Habitat Conservation Ordinance, often referred to just as the Woodland Conservation Ordinance, that some folks may be familiar with through the plans used to implement this ordinance called tree conservation plans. Division 3 is the Tree Canopy Cover Ordinance that is implemented through landscape plans. We are proposing 3 separate bills, one to update Division 2, a separate one to update Division 3, and a third update to the subdivision ordinance. No revisions to the zoning ordinance are needed and won't affect another ongoing legislative effort for minor amendments to the zoning ordinance referred to as the Zoning Ordinance Omnibus Bill. Some of you may be asking, what are these ordinances and how are they used now? The Woodland Conservation Ordinance and the Tree Canopy Cover Ordinance are triggered for any grading permit within the county. And grading permits are triggered when there is movement of dirt or clearing of any areas 5,000 square feet or greater. So these ordinances apply to all development, including residential, commercial, industrial, and institutional. Again, these local ordinances are only implemented with our local permits. Projects that are not subject to our local approving authority are generally reviewed for compliance to the State Forest Conservation Act by the Department of Natural Resources. To put the program into perspective, here's a brief history of our local program. Prince George's County adopted a local woodland conservation program in 1989, effective January 1st, 1990. Prior to the state enacting the Forest Conservation Act in 1991, which required all local jurisdictions to create and implement local programs by 1993. There have been updates to the state requirements over the years that we have adopted along the way, but our most recent overhaul of Subtitle 25 was done in 2010, which is when our local tree canopy cover requirements were enacted. Our Woodland Conservation Ordinance, which is Division 2 of Subtitle 25, is our local program for implementing the requirements coming to us from the state for Forest Conservation Act compliance. Here is a quick overview of the major program changes. I'm starting with stream buffers because that affects the subdivision ordinance as well as the Woodland Conservation Ordinance. Then I will touch on the proposed updates to the Tree Canopy Cover Ordinance, and then the remainder of the topics pertain just to the Woodland Conservation Ordinance. Again, these are the main categories that need to be updated to address the state mandate. The state bill outlined a requirement for fully planted stream buffers, and they set the buffers at 50 feet for intermittent streams and 100 feet for perennial streams. These are designations given to streams based on certain physical characteristics that are determined during on-site evaluations. However, following the buffer widths to the letter for woodland conservation purposes only did not seem very practical to us as we reviewed and got into the details of stream buffers in our county. This is because we already have local stream buffers that are already protected during the development review process. And while not already an outright requirement for forest preservation and planting, they are our highest priority. We were hesitant to add another buffer requirement specifically for planting at widths that would be different from our existing local buffers. So we are proposing to combine the requirements and update the existing stream buffers to have buffer widths that would meet both our current requirements for general preservation and avoidance of impacts, as well as the new planting requirements from the state. Currently, our stream buffers are based on the environmental strategy areas found in Plan 2035. So they're based geographically and not necessarily based on the regulatory status of a stream. Here's a comparison of our existing buffers based on environmental strategy area and our proposed buffers based on location, either within or outside of transit centers. This is consistent with past and current practices for placing a buffer on all regulated streams, with the width being based on location within the county and not based on the differentiation between intermittent and perennial as outlined in the state bills. There are lower forest replacement requirements in transit-oriented centers outlined in the state bills as a method to incentivize development within the centers and reduce sprawl. Along those lines, we are proposing the smallest stream buffers within the centers and larger stream buffers in the rest of the county. We are focusing on the Plan 2035 designated centers that also meet the state's definition of transit-oriented development found in the transportation article. We propose to have a 75-foot buffer within all transit-oriented development centers, regardless of environmental strategy area designation. All others will be 100 feet. We believe this meets the intent of the state legislation while allowing for focus on development within the Plan 2035 designated transit-oriented development centers. And you may note all buffers are proposed to be larger than our existing buffers. I also want to point out that our stream buffer widths are set within our subdivision ordinance, and other ordinances refer back to the subdivision ordinance regarding streams. The update to stream buffers is the only change we are proposing to the subdivision ordinance, which again is needed because of the state requirement for achieving a fully forested stream buffers. As with pretty much any requirements, there are exceptions, some of which were outlined by the state for things that would conflict with allowable uses established for stream buffers and for areas not suitable for preservation or planting of forest in a stream buffer. However, we will be requiring that any project that cannot meet a fully forested stream buffer must submit a statement of justification outlining why the requirement cannot be met, and these will be carefully evaluated. The state has not yet provided the criteria required for these statements of justification for planting or not being able to plant. So we plan to include guidance in our local environmental technical manual, which may need to be adjusted if and when the state provides that standard criteria. We also want to note here that the state has given local programs the ability to adjust our programs as long as it can be demonstrated that the county will meet no net loss of forest. And as you can see in the table, all proposed buffers are larger than our current buffers. Here's a quick high-level summary of proposed stream buffer requirements moving forward, again with widths of 75 feet within the transit-oriented development centers and 100 feet everywhere else in the county. Existing stream buffer requirements are being combined with the state requirements for fully forested stream buffers for all projects reviewed through the entitlement process, as well as all tree conservation plans. And a new statement of justification process will be established to ensure a full evaluation of any project that cannot meet this new requirement. Now shifting to focus on the tree canopy cover ordinance, which is Division 3 of Subtitle 25. While the Woodland Conservation Ordinance focuses on the protection of our biological forests, The tree canopy cover ordinance has a broader focus on general canopy cover throughout the county. We recently had a study done by the University of Vermont looking at data from 2009 to 2020. And I found this map from the study particularly interesting because it clearly indicates the need for more tree canopy within our urban and developed areas. We believe that strengthening the tree canopy cover ordinance will be an important tool in the toolbox for addressing this issue moving forward. And please keep in mind that this ordinance only applies to development applications and permits, which I will cover in more detail in a few slides. But the urban areas will need other tree programs such as street tree planting, a focus on individual tree protection on existing lots, as well as, maybe some incentive programs for planting, things like that, in order to bring more tree canopy to these areas. Currently, the tree canopy cover ordinance applies to all permits proposing 5,000 square feet or more of disturbance, which generally only applies to grading permits. With this update, we are proposing that the tree canopy cover ordinance apply to any permits proposing 2,500 square feet of gross floor area or disturbance. This is intended to subject those projects to tree canopy cover requirements that might otherwise be exempt from the Woodland Conservation Ordinance. This will require the planting of individual trees, even for smaller projects throughout the county, which should help in starting to rebuild our urban forests back up. We are also proposing to reduce the list of exemptions to include only what is listed here. And we are proposing to change the calculations from gross tract to net tract. We believe this switch will ensure that the development envelope outside of the floodplain meets the tree canopy cover requirements and will no longer count the forested floodplain, which must be protected through other county regulations already. This is expected to result in greater tree canopy within the development envelope of a project and will be particularly important in urban areas and areas of redevelopment. We are also proposing to increase the tree canopy cover requirements across the board, with the exception of the rural and agricultural zones. We did take a closer look at the possibility of adding a requirement for these zones, but determined that there may be some farms and agricultural uses that would become subject, and some other unintended consequences. We also came to the same conclusion as when this ordinance was originally introduced in 2010, that most projects in the rural and agricultural zones will have tree canopy requirements that are already met by the overlapping woodland conservation requirements. Here is a quick summary of the proposed updates to the tree canopy cover ordinance. Again, we believe that by implementing these changes, we can start to address issues of equity for canopy cover within the county. From this slide moving forward, all of the topics are specific to Division 2 of Subtitle 25, the Woodland Conservation Ordinance. And the thresholds and replacement requirements for clearing are probably the biggest change and the heart of the intent of the state legislation. The goal of this requirement is for jurisdictions to not only show no net loss of forest, but to strive for an overall increase. Secondarily was to simplify the calculations for replacement requirements. The state bills allow flexibility in how jurisdictions can approach this requirement for clearing, the replacement requirement for clearing. So here's a table of the proposed woodland conservation replacement requirements. One of the changes from the state that was difficult to decide what to do with was an exemption for transit-oriented development, because the exemption outlined the requirement for mitigation, and the state set that at a 1/4-to-1 replacement ratio, which would need to be shown on a mitigation plan, like a tree conservation plan. So we determined for practical implementation purposes, the process should follow the standard tree conservation plan review and approval process in order to demonstrate the mitigation requirements. The transit-oriented development defined by the state does not include our Plan 2035 local centers that are vehicle reliant. So we are proposing an updated definition of transit-oriented centers specific to the Woodland Conservation Ordinance. We believe that the 1/4-to-1 replacement requirement in the transit-oriented centers will incentivize growth in these areas where we are looking to concentrate development and reduce overall urban sprawl. The transit centers will still be subject to any afforestation requirement and to the tree canopy cover ordinance, which will ensure that a minimum urban tree canopy is achieved with all development and redevelopment projects. So in summary of replacement requirements for clearing, development applications will be following the new state standard of 1/4-to-1 replacement within the transit-oriented development centers and 1-to-1 everywhere else in the county. We are proposing that the replacement requirement will be in addition to the minimum woodland conservation or afforestation threshold for a site. Here are the woodland conservation and afforestation thresholds. We are not proposing to make any changes to these thresholds. An afforestation threshold applies to sites that contain very little existing woodland and triggers the need to plant where trees have long been absent from a site. The afforestation threshold requires a minimum % of planting for such sites, and the state did not change the afforestation thresholds. The woodland conservation threshold is a minimum amount of preservation of existing woodland on a site. The state bills did outline the removal of this preservation threshold and attempted to streamline the calculations by only requiring 1-to-1 replacement for clearing, again with no minimum preservation. We do not believe that implementing the state requirements as written will result in no net loss. Our evaluation of the tree conservation plans that were approved in fiscal year 2023 showed that with only a 1-to-1 replacement requirement, the overall numbers were a wash when compared to the plans as approved under our current requirements. So we then looked at including the threshold requirement, which resulted in an overall gain, which is what the state is looking for local programs to demonstrate, and is what our Plan 2035 and our Green Infrastructure Plan outline as goals. So our proposal for woodland calculations will be more stringent than the state minimums and will include the state's replacement requirements for clearing. But we are also proposing to continue to include the thresholds in our woodland conservation calculations. This may not be quite as straightforward as the state intended, but it does simplify the calculation from what we do now and will result in an overall increase in tree canopy cover. We are also proposing to take it a step further to require a variance application for any project that cannot meet the threshold on site. This is to ensure that upon completion of a development project, there is some minimum amount of forest left on a site. A variance is the process for an applicant to demonstrate that there are extenuating circumstances meeting the variance findings. Our goal with this proposed change is that we will no longer be seeing any project proposing to meet 100% of the woodland conservation requirement off-site. This is in keeping with the county's climate action plan and will help address inequities of tree canopy cover distribution within the county by ensuring that every development site has some minimum amount of woodland forest cover upon completion of the project. Here I have outlined a high-level summary of the thresholds and replacement requirements. So now that we've gone over the proposed changes for how a project's woodland requirements will be calculated, I want to shift to how those requirements can be met. While we will now be looking to have the minimum thresholds met on site, and for high priority areas such as stream buffers to be planted, we do anticipate that there will still be the need for some alternative credits and offsite banks to meet a portion of the requirements for some sites. The state bills included language for the granting of woodland credits for alternative environmental techniques, such as the planting of street trees, restoration of forest and habitat, including the removal of invasive species, environmental site design techniques for stormwater management, and landscape credits. Our existing program already grants credits for habitat restoration, and we are proposing to only amend the amount of credits granted to meet what is now outlined by the state. Our program also currently includes credits for the use of street trees and landscaping credits. However, these have proven to be difficult to implement over the years because woodland conservation credits are required to be placed in an easement, and there are often conflicts with street trees because they're typically in public rights of way And likewise, landscaping generally spans areas that cannot be placed in an easement. We are proposing that moving forward, street trees and landscaping credits should only be granted in the transit-oriented development centers. And the last alternative outlined by the state was to allow woodland credits for environmental site design techniques for stormwater management. However, we are recommending that this not be included in our local program. While this may provide extra water quality improvements, it will not provide biologically significant woodland. And we used to allow woodland conservation within stormwater management areas in years past, and the overlapping easements proved to be an issue that we don't want to bring back. And now moving to the woodland conservation banking, which is a process where woodland is established in an easement, and credits from that easement can be sold to meet the requirements of other development projects. In 2021, the state passed the Tree Solutions Now Act, which, among other things, halted the creation of off-site woodland conservation banks established with retention and only allowed the creation of banks using planting credits. The term qualified conservation was added with that legislation to grandfather the use of existing banks that used both retention and planting credits, but still did not allow the establishment of new banks with retention of existing forest at that time. The recent 2023 state bills that we are amending our program now to address altered the definition of qualified conservation to remove the date by which grandfathered banks had to sell off the credits, and also to again allow for the use of retention in the establishment of new banks, with some guardrails outlined in the next couple of slides. New banks with retention are now required to be located in priority forest, and new banks with planting must be located in priority afforestation and reforestation areas. The definitions of priority were updated with the recent state legislation and include things like forest interior dwelling species habitat, Tier 2 watersheds, and other sensitive areas, which I will touch on later in this presentation. For projects approved after the effective date of our local ordinance update, which will need to be July 1st, 2024, only 50% of a project's requirement can be met with off-site retention credits. This can be increased to 60% with written justification to the Maryland Department of Natural Resources, which we intend to do programmatically so that individual projects do not need to each provide justification. Here I have outlined a quick high-level summary of woodland conservation banking. Now moving on to exemptions. Our main takeaway points are listed here. New exemptions coming to us from the state that we have added to our update include agricultural uses, rights of way for energy generating stations, stream restoration and stormwater exemptions that also must meet certain mitigation criteria, forest management, new federal buildings meeting certain criteria, and certain transit-oriented development and multifamily projects will not be made exempt locally as outlined in the state's exemptions, but we plan to include the replacement requirements in the woodland conservation calculations for inclusion on tree conservation plans. Then local changes not coming to us from the state include minor changes to the standard and numbered exemption criteria, and we are proposing to extend the validity period of our exemption letters from 2 to 5 years. This will align with our permitting timeline and allow applicants to get through the permitting process without having to come back to us to reapply for the same exemption more than once. Moving on to public notice, public comments, and judicial review. So transparency and public involvement were big factors behind some of the state changes, and as staff, we agree wholeheartedly with these changes. We know that sometimes seeing the removal of trees is the first time someone may become aware that a project has been approved and is underway. And while the planning department evaluates a significant number of applications through the entitlement process for things like subdivisions and detailed site plan applications, which typically have public notice and hearings, there are uses and zones that do not come through the entitlement process and go straight to permit as by right uses. But we in the environmental planning section see these by right use applications when clearing is proposed, because a tree conservation plan is required to account for the proposed clearing and demonstrate all of the required preservation and replacement requirements have been met. I will get into a little more detail on that in the next couple of slides. So here's the language from the state outlining the new requirement for notice to be provided to abutting and adjacent property owners at least 20 days prior to approval of a tree conservation plan. It breaks down when the notice is triggered and what type of comments can be provided by the public, either just written or written and verbal. While the state has outlined a notice requirement for any proposed clearing within a priority retention area, we are proposing to be more stringent than this new state requirement by requiring notice to be sent for all projects proposing any clearing above 5,000 square feet that triggers a tree conservation plan. This is for many reasons. One reason is because most of the county's forest meets the new definition of priority retention area. This is a draft map of the priority retention area in the county, which includes the elements in the summary list here, with some exceptions that cannot be mapped. Some of the parameters, like forests in urban areas, are not yet defined by the state, so we are not able to map them at this time. Other items in the list are very vague, like contiguous forest, and yet others will need to be considered on a site-by-site basis, such as the environmental setting for a historic site and specimen champion and historic trees. DNR is tasked with providing a definition of and a map for urban forest in the state manual, but that is not required to be complete until December 31st, 2024. So we expect the forest meeting this updated definition will expand, especially within the developed areas of the county. So instead of analyzing each application for whether it is within or outside of the priority retention area, we are proposing that all tree conservation plans require notice. Again, because such a significant portion of the county contains priority forest, but also for streamlining of processes so that applicants and staff know what is expected and it won't differ between tree conservation plan applications. This will also provide more transparency to the public who may not follow the nuances of why some projects would provide notice and others may not. The notice must outline the type of comments that may be provided by the abutting and adjacent property owners. Again, the notice for any clearing that triggers a tree conservation plan would outline at minimum written comments. If a project is showing clearing of 75% or more of the existing woodland on a site, 5 acres or larger, comments can be provided both in writing or verbally. This would occur as part of the existing development review division processes for any tree conservation plan companion to those entitlement cases. Any standalone tree conservation plan that is processed by the environmental planning section that triggers the verbal comments would need to be heard by the planning board. Here's the language from the state bills regarding judicial review. A petition for judicial review must be filed within 30 days after approval of the tree conservation plan and is limited to the record for the tree conservation plan. Here is a summary of the proposed public notice and comment requirements, as well as the judicial review requirements.
So Megan, while you take a breath here for a second, I just wanted to assure everybody, we are getting your questions. They are getting through to us, and the environmental planning team, we're reviewing them right now and trying to group things as they are, groupable. So just so you know, we are listening and we hear you.
Thank you, Maureen. Moving on to updates on written findings and statements of justification. Here is a breakdown of the justification statements we already require and the newly added ones. Impacts to priority retention areas now require written findings per the state bill. Not a full variance, but additional steps for consideration prior to clearing. The state has not yet provided the criteria that must be met for the written findings demonstrating justification for the clearing, but we anticipate providing something locally in the environmental technical manual that may need to be revised if the state comes out with something different in the future. These written findings will be included in the record of tree conservation plan review and approval, for the record in the case of a hearing, or for our file for planning director level approvals. We plan to provide additional guidance on this topic in the environmental technical manual update, and we'll be looking for opportunities to combine statement of justification requirements where we can. And our last topic of the evening is grandfathering. Here's a quick list of the updates to the Woodland Conservation Ordinance that have been approved since the program's establishment. These dates are important for grandfathering because we are proposing the expiration of all tree conservation plans approved under all of the ordinances prior to 2010. This would apply on the effective date of this legislation, which again, we are assuming will be July 1st, 2024 to match the state's effective date, for projects that are not vested by that date. Plans accepted or approved between September 12th, 2010 and July 1st, 2024 will have a transition time for validity. We are proposing that these plans will expire on July 1st, 2028. And these plans will continue to be grandfathered during this time frame unless a major revision to the plan is proposed. And Woodland Conservation Bank applications that were submitted before December 31st, 2020 will also be grandfathered per the state bills. Here are the criteria of the major and minor plan revisions. As you can see, minor revisions are for very minor changes to an application, and any application that does not meet the criteria for a minor revision will be considered a major revision and will be subject to the requirements of the updated ordinance. And here is a quick summary of grandfathering. So that wraps up the information we have to share about the proposed program changes. I would like to again emphasize that we had a very tight time frame to determine what the state bills were legally requiring, how to best incorporate the changes into our local program. We needed to determine which sections of our ordinances needed to be updated and make those proposed revisions, all while pulling data and performing evaluations to ensure that our proposal moving forward makes sense within the context of our local ordinances applicability. And lastly, to ensure that the proposed revisions would meet the overarching goals of the state bills, which were to demonstrate no net loss of forest and even to demonstrate gain, simplifying the clearing replacement calculations and making the process more transparent to the public. And we are confident that our proposal meets all of these goals set by the state bills. We are happy to have such a strong turnout for tonight's meeting. And on behalf of the planning department, we thank you all for attending. As mentioned at the beginning of the meeting, we are in a very tight time frame for the proposed legislation. In order to meet the effective date of July 1st, 2024, we need to transmit the proposed bills to the county council as soon as possible so that the legislative process can get started. We would encourage anyone who has questions or concerns about the proposed program changes to participate in the legislative process and provide comments through the official channels. I will now turn to our moderator and the environmental planning section team to see what questions we had in the Q&A during the presentation and to see if we are able to at least discuss some of them during the remaining time that we have this evening. Before we start our discussion, I do want to point to the contact information on the screen to direct anyone with site-specific questions to the appropriate entity to address the concerns. And we'll leave this up for reference during our panel discussion. So, Tom, what questions did we have this evening?
Yes, thank you, Megan. We did have many questions come in. I'm not exactly sure I think what I'll do is I'll publish them as we go along. So our first question was, how will the new the new stream buffers be treated for sites with an approved NRI? So whereas there is grandfathering for the TCPs in certain circumstances, we did not apply any grandfathering to the NRI. So at this point, what we're proposing is that where there is a conflict with the stream buffers, the NRI will need to be amended to provide the corrected buffer. So that was question number one. Question two. Wait a minute. Okay. Okay. Question two, will replacement trees, I'll publish that. Will replacement trees be required to be planted within the same city or town they are removed from? So not necessarily within the same city or town, but the code will prioritize replacement on site. If there is no way to meet the reforestation on site, then we prioritize off site. And within the same watershed. It's similar to the existing ordinance. Megan, do you have anything to add to that? I think that covers that. Okay, question number three. Okay, question number three is kind of a long one here. What process for appeal to the enforcement of woodland and wildlife habitat and tree canopy violations is being implemented in the policies and procedures? Currently, there is no separation between those that committed a violation and those that did not. Innocent individuals are being held accountable for violations committed by previous property owners. Those innocent individuals are being penalized upwards of $70,000 for crimes committed by sellers of residential properties. This is so the enforcement and how that's carried out is primarily it's by DPI, the Department of Permitting, Inspections and Enforcement. The best way I believe that they have to process those is that the issues run with the land. Before closing a TCP2, before closing on a property, a TCP2 is required to be given to a buyer. And it's the responsibility of the buyer to make sure that there are no liens or violations on that site. So theoretically, that shouldn't be happening if due diligence is being done by not just the purchaser, but by their real estate professionals. And we do get inquiries all the time about those. So that was the third question. Let's see. Okay. The question. All right. These questions keep rolling in, and that's jamming up the system here. Okay. Okay. Does this proposed revision meet or exceed the recommendations in the climate action plan for no net tree loss and for protecting vulnerable populations from excess heat? Is that something, Megan, you want to take that question?
Sure. So the goal the requirement coming from the state is no net loss. There is language in there encouraging a net increase. When we ran the numbers based on prior approvals, we believe that what we are putting forth will provide not only no net loss, but also a gain. As I mentioned in the presentation, the state is requiring just a straight one-to-one replacement, right? You clear an acre of trees, you put an acre of trees back. When we compared that to our current requirements, we were finding that there wasn't the one-to-one requirement and the calculations that we do now were kind of a wash. So we took it a step further than the state minimum of the one-to-one replacement and are proposing to have minimum thresholds be part of that calculation moving forward. So there will be a minimum amount of preservation or a minimum amount of afforestation planting to get up to a certain threshold. And then beyond that, or in addition to that, there would be a one-to-one replacement requirement for any clearing. And we believe that based on our calculations and our evaluations, that will get us to a net increase. There was one of the maps that I showed from the study that we had show that there is disparity in our tree canopy cover and in between the updates to the Woodland Conservation Ordinance and the tree canopy cover ordinance. We believe we can start to close that gap. I do think that there will be a need for probably some additional tree canopy programs in the county to kind of help close that gap. Specifically for heat island effect, we did not look at that specifically. It's not a requirement coming to us from the state. So it wasn't kind of baked into the requirements of our existing program or the requirements from the state for the update, but it is certainly something that we will be coordinating with our Department of the Environment on moving forward, because I know there are aspects in the climate action plan that call for that. So.
Okay, thank you.
Yep.
Okay, the next question, Kim Finch, I'm going to let you field this one. Oops, wait a minute. Sorry, just disappeared on me. Okay, please explain how this proposal addresses tree equity. Will it protect wooded areas and more mature trees in our more densely populated areas inside the Beltway with lower conservation thresholds in the zones with more dense development and lower replacement requirements for projects in TOD areas? How will we ensure that we are not removing trees from where they are needed most and planting them in areas where trees are currently plentiful? Kim Finch, are you able to answer that question? Kim Finch, are you there?
Tom, I can field this one if you want.
Okay, yeah, very good, thank you. Okay, thank you.
Sure. So, actually, can you repeat it again?
Yeah, sure. And it is, yeah, let me pull
Thanks.
that up here. So this is about equity. Where did it go? Published. Okay. Okay. Please explain how this proposal addresses tree equity. Will it protect wooded areas in more mature trees in our more densely populated areas inside the Beltway? That's saying with the lower conservation thresholds in the zone with more dense development and lower replacement requirements for projects in TOD areas, how will we ensure that we are not removing trees from where they are needed most and planting them in areas where trees are currently plentiful?
Okay. I see it now in the publisher. Sorry,
Excellent.
we're all as
That's
staff
okay.
getting used to the Q&A as well. So I would say that a lot of the more mature trees tend to be along our stream valleys. And that is a place that is a high priority for preservation. Again, with us taking it a step further than the state in requiring not just one-to-one replacement, we are placing an emphasis on, at least a minimum amount of preservation on every site moving forward. And we are looking to have that minimum amount of preservation be in those sensitive areas. If there's a site, in a densely populated area that is, maybe being redeveloped, maybe there aren't any streams, but there might be a specimen tree or some other, more mature tree, then the focus would be on trying to preserve that existing canopy moving forward. I mean, I think the protection is kind of baked into the process and the requirements. So I don't think we specifically called anything out for the urban areas in particular, because again, there will be a minimum amount of preservation that we're looking for on every site, and that highest priority is, of course, the more mature trees.
That's right. Okay. Let's see. Okay, here is a question. Will existing exemptions automatically be extended to 5 years from the original approval date? So the answer there, I believe, is no, that those exemptions will not. That the existing, so we're talking about Woodland Conservation Ordinance exemption letters. I believe that they currently are valid for 2 years and they're extending to 5. And it's my understanding with this that what we'll be doing is they will expire after the 2 years, and then a new one will be required that will have a durability of 5 years. Okay. Next question. Oh. Okay. So the next question is, how do these changes address climate action plan recommendations that mitigation be within the same sub-watershed? Megan, do you want to take that one?
Yeah, is it in the published? It's kind of easier for me to be able to read it.
I know, and yeah. So
there.
So I'm as I'm reading them,
Got it.
or what I'm doing is I'm reading them and then publishing them, just
Okay.
because then they disappear from in review, and I can't go back to them. So I need to read them. Yeah.
Okay, I see it. We're good. So how do the changes address the climate action plan recommendation within the same sub-watershed? So there is a requirement at time of permits that requires any mitigation that cannot be met on a site to demonstrate due diligence in a hierarchy of providing those offsite credits. So if an applicant would have to demonstrate first that there were no credits available in the sub-watershed, and then kind of go out from there to the larger watershed. And lastly, of course, we require that those credits be granted within the county. So it is a current requirement, and it will continue moving forward.
Thank you. Next question is, please define transit-oriented development and transit in general. Does it refer only to public transportation? What about sites near busy roads and intersections? So the Woodland Conservation Ordinance, the proposed or the draft ordinance we have does have a definition of transit-oriented centers, and those are defined as transit-oriented development, which is consistent with the Maryland 7-101 of the transportation article and are identified within Plan 2035. This does not include those areas defined as local town centers in Plan 2035. It does not, and it does not apply to busy intersections and major roadways. Okay. Okay. Let's see here. Sorry, these things just keep rolling here. Okay, please explain please explain how a statement of justification is evaluated. So, Mark Juba, do you want to answer that one?
Sure thing, Tom. So depending on how depending on what the statement of justification is for, it would either be reviewed with planning board or by the director, or in certain cases at district council. So it depends on what type of variance is being applied.
That's right. And yeah, and then exactly. Thank you. Okay. All right. The next question. Here we go. Does the reforestation of all stream buffers requirements include the primary management areas, expanded stream buffers also, or just the minimum buffers? So, Megan, can you answer that question?
Sure. The simple answer is it's both. So the stream buffer is the planting requirement just in the width from the stream. It will often be part of the primary management area, but the primary management area may extend beyond the minimum stream buffer for things like steep slopes, wetland buffers, things like that, a floodplain. So it's possible that the planting requirement for a stream may be smaller than the primary management area delineation, but all that area would be subject to the avoidance and minimization requirements that we have.
Thank you. Okay. Then next question, if a project does not have a revision in woodland conservation, but needs to remove a new specimen tree, is that a major revision? I'm not sure we've established that at this point.
Actually, we have.
Okay, very good.
We've established that if there is going to be any adverse effects to a specimen champion historic tree, it wouldn't be able to go through the minor revision process. It would be considered a major revision.
It would be considered a major revision. I'm sorry.
Correct. Yes.
Okay, great. Thank you. Okay, does the new law affect then does the new law affect the definition of a significant tree as one with a DBH at least 30 inches? Tacoma Parks is 7.5 inches and Moco's is 24 inches, Moco being Montgomery County. Mark, you're on a roll, and I think you got the answer to this one.
So we put a provision within the definition section for significant tree being defined as 24 inches or greater, but we haven't put much into the rewrite right now, much more beyond that. We're looking at trying to put more language within the ETM once we get to it at that time.
All right, the ETM being the environmental technical manual.
Environmental technical manual, yes.
And that, yeah, which is something that will be published sometime after the new regs go into place.
Right.
Okay. Next question. Does the new law okay, never mind. That was the one we just read. Okay. RE regarding exemptions. 1, are solar energy facilities exempt? 2, what federal facilities are exempt and why? And 3, how do requirements for transit-oriented development and multifamily projects differ from requirements for other projects? Megan, is that something you can answer? There we go. I just published that.
Thanks.
Mhm.
There it is. So are solar energy facilities exempt? The short answer is no. I know that there was some language in the recent state legislation regarding solar. We have we currently subject solar projects to the Woodland Conservation Ordinance. Moving forward, we don't anticipate any change to that. So the one change was made to the transmission lines. So if there is like a really big facility and they've got a transmission line, then the lines themselves, I think, are exempt, but the facility itself, not necessarily. What federal facilities are exempt and why? There was an exemption for, I think if the federal facility had a certain number of employees, it would be exempt from the woodland conservation requirements. It was in the state legislation. It was one of the exemptions, and we, incorporated that into the local program. How do requirements for transit-oriented development and multifamily projects differ from requirements for other projects? So in the state bill, they called it an exemption, but then, exemptions you think of are just exempt, right? They don't have any requirements. But the state outlined certain mitigation requirements for these exemptions. And so for the transit-oriented development centers, their mitigation was just a lower replacement requirement. So everywhere else, it's going to be 1-to-1 replacement, but in the transit-oriented centers, it's 1/4-to-1. Multifamily projects, I don't remember that off the top of my head, but I think actually, I'm not sure we carried that forward into our local. I think it was just
No.
inside the transit centers or outside of
That's
the
right.
transit centers. I think we were thinking that most of the multifamily, or where we're trying to have the multifamily, is in those transit-oriented centers, and so that is what we focused on in the update.
Right. Okay. And the final one I have here for discussion there, unless I'm missing something here. So this is, please, who would be the appropriate contact for municipalities to discuss specific effects of this subtitle to municipal jurisdiction, public property, private property, planning, parks, county agency? Thank you. So I think, so we are the appropriate contacts. So I think that, yeah, Megan has the county agencies, but it would be our team who you would contact about that specifically.
And I would just add that if Megan, you can just explain to the attendees their opportunity to weigh in on the public hearing with the council for this. I'm sorry if that's probably in your plan, but I just kind of that question kind of triggered that thought in my head, and I don't want us to miss the opportunity to
Sure.
let them know that.
Yeah, so the next step in the process is for us to transmit to the council the proposed bills that we have put together based on the state requirements. And we are hopeful that will get the legislative process rolling. And we would encourage folks to participate in that legislative process, in the public hearings, in the readings of the bills, that sort of thing, and provide comments, through that process. But we are the staff who implement this. When the rubber meets the road, we are the ones, reviewing this on a daily basis. And so if there are questions, we are happy to discuss, as anyone would like. But again, the official channels for comments, once the bills are introduced, would be through the legislative process with the council.
Okay, well, that wraps up the questions in that we had in the Q&A here. This has been, yeah, this has been great. A lot of good questions came in. I think we went through all of them, all of the questions. There were a few duplicates in there. But if you feel like maybe your question wasn't answered, then or if you have further questions, feel free to contact us and we'll see what we can do. Okay.
Okay, everyone, thank you so very much for joining us. Please contact our office if you have any additional questions. We look forward to seeing you at the public hearing for this. And again, just please reach out if you have any concerns. Thank you again and have a good evening.
Thank you, everyone.
Thank you all.
Take
Thank
care.
you. Good night. Thank you, Megan.